Over to you, ma'am.
Thank you so much, Janvi, for such a great welcome. Okay, so may I just start my session?
Yeah, sure, ma'am. Go ahead.
Okay. So good afternoon to everyone present here. So today's topic is criminal pleading with special reference to FIR and complaint. So basically, every one of the, every law student or every person who is in the law field right now has they have a keen interest for criminal stuff, right? Everyone wants to be in that criminal things. More of the people are into the criminal proceedings, into the criminal zone, because today's era we see everything related to the crime. And as in the world of today, we see that even the movies, even the web series we see are related to law. Actually, law is becoming trending these days. So everyone is interested to know how the things are done, how the things are to be done. We see in this movies and web series that yeah, these are the things that should be done. But actually, are they even correct? Or even being a law student, we have a rough idea about everything that okay, FIR will be there, complaint will be there, we'll do this, we'll do that, police can do this, police cannot do that. So we have always been into dilemma of what is actually correct. And you know what, the answer is just in our books, that is the the criminal procedure code. Nothing is beyond it. Actually, when we study each and every part of it, we can get enlightened by it. So today I'll be discussing about the exact procedure, how and why, and what is the criteria, what is the evidentiary value, what is the on what basis, and how and by whom the FIR is launched, where, or what is the evidentiary value of FIR, who can file FIR, and who will register the FIR, what is the criteria, and everything about the FIR, and of course the complaint that is a part of it. So I would like to start with the thing that if we have what is the main zone of a particular trial, that is three things are there. The first is your investigation, then it's your inquiry, and then the trial goes. I'll not be dealing exactly into the sections of this particular WARE Act or Criminal Procedure Code. I'll be dealing with sections a little so you can read it by yourself, but I'll be dealing with the content. Basically, what is in it. So what exactly we miss all the time is what is inside the section. What is the main clause inside it we are missing. So that I'm going to discuss. So there is an investigation, inquiry, and trial. So basically, everyone know what is investigation and inquiry and trial. So these three can overlap each other sometimes, but not inquiry and trial. Inquiry and trial does not overlap each other. Investigation is what when we when we go and get an FIR done, till the cognizance is taken by the magistrate, that particular thing is investigation. And since the cognizance is taken by the magistrate until the charge sheet is filed, that particular area in between, whatever the happenings of the event, will be considered as inquiry. And inquiry is strictly done by magistrate. Nobody else can do the inquiry. And then as soon as the charge sheet is filed, the inquiry ends and the trial begins. And at the end of the trial, there is a judgment, right? So now I'm going to tell about the FIR. First of all, there is no such word FIR in the whole criminal procedure code. There is no word defining FIR. There is nothing, first investigation report. Nothing is in the whole, CRPC. No, nothing is defined like that. The word used in the irrespective of it is information. Information, that is the only word used in the law. So information, we says that whosoever comes first to the police station provides the information. That is why we says it's a FIR, first investigation report, right? Now the question is, if the word is the information word is only used, so we define that word as an FIR. It's like for our convenience, we say it's an FIR, but in terms of law, it is not an FIR. It's just an information. Why the word information has been used? Because when there is an offense committed by any of the person against, for an example, an offense is committed against me. So I'll be going to the police station with an information, right? I don't know whether that offense is what kind of offense, whether it's a cognizable offense or it's a non-cognizable offense. I'm a layman person, right? For an example, I'm a layman person. I don't know what's this cognizance, non-cognizance. So I'll just go to the police station with the information. That is why the word information is given. Because if I'm gonna say it's a cognizable offense, if I'm gonna say non-cognizable offense, no one will be understanding that right now. So I'll go with the information. That is the only sole reason behind that FIR word is not used, the information word is used, because we go to the police station, we are not clear what offense has been committed against us, what kind of offense. Okay, so now so I'll start with the cognizance of cognizable offenses. So how does it goes? Like, if a person has gone to the police station with the information that a particular offense or omission has been committed against him or her, so he will go to the police station. He'll say, please take my complaint. This complaint is journal complaint. I'm not talking about the complaint which is defined under criminal procedure code. I'm just talking about the complaint. Just take my complaint. This offense has been committed against me. So now the police person will see that this particular offense is cognizable offense or non-cognizable offense. So now the question arises that what is cognizable and what is non-cognizable offense. You might have studied in your WR.t and everything that cognizable offense is this, where there is a punishment above 3 years, and there is punishment above 3 years are cognizable offense, and punishment below 3 years are non-cognizable offense. Like that we have studied. But let's go a little deep inside it. Actually, what is cognizable offense? That is defined under 2 clause C of CRPC. You people can go and read it after the session, or between the session, you can open the WR.t as well. There's no issue. So the first two ingredients of 2 clause C, that is cognizable offense, is there cannot be an arrest without warrant. Oh, sorry, arrest without warrant. There can be arrest without warrant, right? If police is feeling that there need to be arrest done, then they don't need to have a warrant for that. They can arrest any person without the warrant. And the second thing is, there is no need to take an order from the magistrate to do the investigation, right? So 2 things are more clear here. No warrant is required, and no order for investigation is required under the cognizable offense. Now, if we see the cognizable offense, what is it actually cognizable offense is? It is according to the schedule of the act, right? In schedule, we have 2 parts. If you go in the schedule of this particular Bayer Act, that schedule is given, schedule 1, and that have 2 parts. The part 1 says the IPC offenses, right? The part 1 is like whatever the offense are defined under IPC, all those offenses list is given, and the year is given, or the punishment is given, that this for this offense, this much punishment, for this offense, this much punishment. So that criteria we were talking about, that above 3 years punishment will be considered as cognizable offense, it is there, but it is there with some other thing. So if you see the part 1 of schedule 1, part 1 of the particular Bayer Act, you will see that IPC offenses has been defined, and they doesn't have a uniformity. What I'm talking about uniformity is that if you see an example of AFRE in IPC, if you see in the particular schedule, the punishment for AFRE is given 1 month, right? And now if you see 1 month, if the punishment is 1 month, then it should be an offense of non-cognizable. It should be a non-cognizable offense, right? It should be. But no, it is not, because there is no uniformity created in the part 1 of the schedule 1 in under CRPC. So every time there is an offense committed, the person has to check the schedule 1 when the offenses of the IPCs, right? So no uniformity is created. But under the schedule 1 part 2, if you see all the other offenses, they have a uniformity. Like the punishment, which are above 3 years, will be considered as cognizable offenses. So am I clear with this? So if we see 2C is about schedule 1 part 1 and schedule 1 part 2. Part 1 doesn't have the uniformity. You have to check every time whatever the IPC offenses has been committed, you have to check the schedule 1, whether it's a cognizable or non-cognizable. And when you see the part 2, you have a uniformity of 3 years above punishment is considered as cognizable offenses. Now, the particular person, let's just take an example for the whole session, like X, right? So X has gone to the police station. He gives the information to the police officer, and the police officer considered that particular offense as a cognizable offense, right? The police officer found it that it's a cognizable offense. Now, what is to be done? What police officer will be dealing with? Now, what do we do? What to be done? What he'll do is he'll register that as an FIR. First information report he got from that particular person X, now he will register it. So basically, now the FIR comes into the role play. If there is a cognizable offense committed against you or any person or against anyone, then you give the information to the police officer. Then he'll consider it whether it's a cognizable or non-cognizable. If it's a cognizable offense, the FIR will be launched. So the sections dealing with the FIR are 154 and 156 generally, I would consider. Because if we see into the more, broad perspective, we can say that after section 154, 156, if anybody is not able to, get their FIR registered, they can go high court as well. Like under 266, they can go Supreme Court under Article 32. So those are the broad perspective. But when it comes to the criminal pleadings in the terms of FIR, the two sections we deal with is 154 and 156. And they are quite complementary to each other. Like they go hand in hand, actually, right? So you can just open your bare acts, or you can even read out the sections, because I'm going to deal with every clause of it. And you will get to know, okay, this is the particular procedure to be done when you have to register an FIR. So now the X has given that okay, fine, murder has been committed against this person, against this person.
Can you please request it to, yeah, ma'am, please go ahead.
Okay, thank you. So now he will register an FIR. And what is the procedure now? What is the exact procedure? Whatever the information X will be giving to the police officer, he will write that particular information. He'll write that in a particular diary maintained by the police officer. He'll be writing it. Then after whatever the information you're going to give to him, he'll write down, pen it down, and he'll ask you to sign on it, because X is the person who has given the information to him. So the police officer will ask the X to sign the particular FIR, whatever the information he has provided. What if X wants to refuse it, that I don't want to sign it? Is there anything that you can do about it? What is the consequences of refusing now? You have come to the police station, you have asked for FIR to be registered. Now FIR has been registered. Now you need to sign it, but you're not signing it. What is the consequences of it? There are consequences. The consequences is that if you're going to refuse to sign on the FIR, you will be booked under section 180 of IPC. Okay, so it's like mandatory. The signature is mandatory if the person is coming to the police station for lodging an FIR. After that, a copy of particular, FIR will be given to you. Whosoever has come for an FIR lodging, that person will be given the copy of the particular FIR. Okay. Now, the main problem is that sometimes we want to go and register an FIR we want an FIR to be registered, but the police officer denies us that no, I'll not be registering your FIR, or he's making some excuses saying come tomorrow, or get some good point, or etc., that he's not ready. He's not convinced to register an FIR. What you can do now? What you can do is, you can go to his superintendent officer, right? Superintendent person, more senior to him. You can go and ask him that the particular inspector is not taking my FIR or not lodging my FIR. Please help me. Or I will not say please help me. He will ask that to do the certain actions. So the superintendent will be asking the person, the inspector who was not filing the FIR, to lodge an FIR, or otherwise he'll do by himself, right? So these are the things, three things I explained, that it should be written, signed, first clause, If not signed, you will be booked under IPC. Second, the copy of the FIR will be provided to you. And third, if the inspector is denying to have a lodge an FIR, then you can go to the superintendent, right? So these three things are defined under 154. If you open the section 154 of CRPC, you will be having these kinds of clauses in it. Now, I said 154 is complementary or goes hand in hand with 156. So what is exactly this 156 is? And the main question is, what if the offense has been committed in Delhi and a person is filing an FIR in Mumbai, right? Like no jurisdiction. You all know what is jurisdiction, because I think it's very, I'm just taking a presumption that everybody's know what jurisdiction is, right? So what if that particular jurisdiction is nowhere to be there? So how can a person file an FIR? If, like, for an example, I take a person committed a crime in Delhi. First, he murdered A in Delhi. Then he went to like in the way went he was going Haryana, and in between in Sonipat he did a theft. Okay, and again he went away, and the particular theft was done by some, and then again into some other city he committed some other offense. Right now he has committed 3 offenses, so with 3 different persons. So every person has a right to, file an FIR against him in different person. This is a normal FIR to be done. I'm asking now, he has committed an offense somewhere else like Delhi, and a person is trying to file an FIR in Mumbai. What is the consequences of it? Whether the FIR will be done, whether the FIR can be filed or not. So 156 answers that. Jurisdiction plays an important role in FIR. Obviously, the jurisdiction should be there if you have to file an FIR. But if there is a situation where you are helpless, that you cannot go there or file an FIR, or you have some basis to not to file an FIR or somewhere else, so you can file an FIR to that particular area where you belong. Why? Because this particular FIR, filing an FIR won't be, doing injustice. There would be no, I would say, there would it would not be an injustice. It would not be a thing that would take away the main essence of FIR, right? If person is having some grief or anything, so he can go to the police station. So mere on the ground that the jurisdiction was not right, he will not be denied, right? So where this is given under section 156, what I'm talking about, that if on the basis of mere jurisdiction, if the jurisdiction is wrong, or the police officer who is not have an authority to take to file lodge an FIR, if he does it, or the person who has no authority to file a FIR in particular area which he was bound to, so it's a curable irregularity, right? Curable irregularity, what do you mean by that? That you can file, it doesn't matter, it won't make your case go bad, right? So it's a good in law. So it's a curable irregularity. The irregularity has happened, so you can make it right in some other make it right somehow, or you can transfer the FIR to the particular police station, or you can ask the particular inspector that from now you handle the FIR. So these things are very much curable, so there nothing goes wrong in there. The second situation is, the first situation is very much clear, that jurisdiction is just a mere irregularity which can be curable in the future. The second question is about the FIR is that what if offense has been committed in a 3 place with the same person. For an example, like a person A kidnapped B in Delhi, okay, and then he kidnapped him in the car, B, and then they were moving they crossed Delhi to Haryana, and A committed a rape on B in Haryana. So the second offense is in Haryana. Then and he committed a rape on her, then murdered her, right? And murdered her, and after that he buried his body, her body, in some other city, maybe Punjab, right? So this is what goes: Delhi, Haryana, and Punjab. Same person, different acts. So where the FIR can be filed? Tell me. The three things are there. First, happening of the first event was kidnapping. The effect of the kidnapping was held in Haryana, where he committed the rape and murder. Third, the consequences. The body was buried in Punjab. So these are the three things. So where the FIR can be filed? Anywhere. In these three areas, anywhere. Because all of the three places are very much, competent to be lodged in FIR. So what we see is here the happening, the consequences, or the happening, the effect, and the end consequences of the particular act. So wherever these three things are found in the three states, or any different three particular areas, any three area we can file an FIR. So is it clear? Now I will deal, these two clauses are under 156, that is section 156, where the jurisdiction has been talked about and the curable irregularity has been talked about. Now, if you see 156 clause 3, that is the most important section in the CRPC with relate to the FIR. That is the magistrate power to lodge an FIR. What if SP has denied? What if his police inspector has denied? Everyone has denied to launch an FIR. So magistrate has a right to ask the PO or the superintendent to lodge an FIR. This is the power given to the magistrate. And why this particular section 156 clause 3 is so much important, that I'll be dealing it when we'll deal with the complaint, because here that is important, right? So basically, this section, magistrate to direct the person to direct the police officer to lodge an FIR is important, because if we have no way around, that nobody is filing an FIR, or nobody's, FIR is the main criteria, very important to do, because you have to proceed the further case, or investigation has to be done. So we can ask the magistrate to take an action. It's basically, we are asking magistrate that nobody is filing an FIR, neither the police, neither the superintendent, nobody's listening. So you take an action on this, because we have this particular problem. So you take an action and you take an action and help us to file an FIR. So magistrate, under his power of this 156 clause 3, will direct the PO to register an FIR, right? So this is the most important section you should look for. So now what is all this will happen 154, 156, whatever the situation or criteria will be there, this particular FIR will be filed, and the particulars mandatory investigation will be done, because we don't need to take an order of investigation or arrest warrant from the magistrate in cognizable cases. So the police will be doing their investigation. If there is any suspicious on somebody, they'll arrest that particular person, and everything will be done, and there will be a PR created. What is this PR? This word is usually used in the courts, not in the books, but the PR means police report. The police will make a report of everything and will be submitting it to the magistrate that this thing happened, this, and whatever the information of the whole case, he'll write down, pen down, and will be submitting it to the magistrate, right? This is the key ingredient, that police report has to be mandatory to be submitted. And where this particular police report is submitted, section is 173 clause 2, but it's just normal procedure. So you just remember the procedure right now, not into the sections, because obviously when you will be studying for yourself, or will be doing your exam, so you'll be very much clear, but at least know the content of the section rather than the section, right? So this is the thing. So we have got to know that cognizable offense, we have an FIR, and FIR 154, 156, this is the particular procedure, and this is the thing. So FIR, let's deal with some other questions as well with FIR, like a little thing that we have, like where this particular FIR is written. It's in a daily diary of the police inspectors. They have a daily diary with them. They write in the daily diary of that particular FIR, whichever is coming. And there are types of FIR. So let me just give a little view about them. That is cross FIR. Cross FIR is like if I want to file an FIR against X and X also wants to file an FIR against me. So this is like cross FIR. Both want to file an FIR against each other. Okay. So, and for cross FIR, then we'll have a multiple FIR. What if I want to file an FIR against X that he has committed some offense against me? Today, I went to the police station, filed an FIR. Next day, I went to police station, say he has committed this also. I'll say, okay, police inspector will write that FIR also. Now, third day, I'll say, now he did trespass. The fourth day, he has committed this, he has committed that. So there are like by me, by the same person, many FIRs has been filed. So which FIR will be considered? This is the biggest question. Now, many FIR has been filed. So which FIR will be, considered valuable? So FIR, which was filed at the first instance, okay, will be considered. But what if the first FIR has lesser value than the last FIR which I have filed? So which FIR will be done? The general principle says the first FIR will be first FIR will be taken into consideration or will be given the value. But if the FIR which have more, reliable information will be considered. That is like a subjective concept, right? The police officer has to see it. But the general principle says first FIR will have an evidentiary value, other FIR will not be having any evidentiary value. But if the other FIR which has a more reliable information, then that will be considered. So the cross FIR, multiple FIR, and the very trendy concept in these days are zero FIR. So what's exactly this zero FIR is? Zero FIR is nothing. The zero FIR is where there is no jurisdiction, but you try to file an FIR over there. So what the police inspector do? What he do is, where the FIR has to be registered in a particular police diary. I told now there is some police diary and you have to file, you have to register the FIR over there. So rather than having that particular police diary and maintaining that record, the police officer will write at the back of the police diary the information which has been given to him. So he'll not be launching the FIR in a very particular manner, but he will write the information and lodge an FIR, zero FIR, at the back of the diary. He'll note down the page, he'll note down the number, and he'll note down the place where the FIR has to be filed, but the particular person is filing FIR right now. So he'll be filing an FIR over there in the back of the diary. And afterwards, what he'll do, he'll inform the particular police station where this particular FIR has to be filed. Means where FIR has to be filed at the particular one place. The person has not, for an example, if FIR has to be filed in Mumbai, but I have filed in Delhi. So the Delhi police inspector will write the FIR in the back of the police diary and he will number it. And later on, he can inform that Mumbai's police station that this particular FIR has come, and he will transfer that particular information or FIR to that Mumbai's police station. So this is what is zero FIR is. And no police officer can deny to, launch an FIR, whether it's out of jurisdiction or within the jurisdiction. Nobody has the right to do that. And if they are doing it, then you have consequences. You can go to the superintendent or you can directly go to the magistrate. So these are the mainly informations of FIR. And is FIR a public document or a privileged document? This is the question doesn't come up, but it's a public document. It's not a private document, right? So you can also get an FIR copy anywhere, anytime. So this particular FIR session has been done, and now I'll be dealing with we have dealt with the cognizable cases. Now we will deal with the non-cognizable cases. What exactly happened when you give the information to the police officer and the information you has given is a non-cognizable offense. So in cognizable offense, we saw FIR was to be launched, right? But now in non-cognizable offense, FIR is not launched. What launched is over here is basically NCR. NCR is a non-cognizable report, right? What is this non-cognizable offense? Non-cognizable offense, I would go with the same flow. Like in the cognizable offense, we saw there is Schedule 1 Part 1 and Schedule 1 Part 2. So in also non-cognizable offense, Schedule 1 Part 1, the IPC offenses, there is no uniformity. But in Schedule 1 Part 2, there is a uniformity. That is, if the cases, if the offense is punishable less than 3 years, it will be considered a non-cognizable offenses. And in non-cognizable offenses, we have two ingredients. That is, there cannot be a investigation without the order of the magistrate. So the police inspector, if receive a information that is a non-cognizable offense, so he has to first ask the magistrate whether he can do the investigation or not. And if he wants to arrest any particular person, he has to take the warrant from the magistrate. He cannot do anything. If he does this particular thing, there will be consequences that I'll be dealing in the section. So NCR is to be registered. There is nothing like FIR concept. So the offenses which have a punishable, other offenses which have a punishment less than 3 years, or according to the Schedule 1 Part 1, the whatever offenses we have, so those, for those offenses, there will be an NCR. So how this NCR will work, how, like FIR, I've told the whole procedure. So what is the procedure for NCR? In NCR, if the information is received, the police inspector will write it, will ask you to sign it, and will write the, and will make a register, and will note down your information, and will register it in the non-NCR register, like non-cognizable report register. He will pen it down. And he will give a particular, like in the FIR, you got the copy, right? That you got the copy for particular FIR when the police inspector wrote the FIR. But NCR, you won't get the copy. It's not compulsory that you will get the copy, but there is no hard and fast rule. But the copy has to be sent to the magistrate for NCR. This is the main important thing. Why? Because if you won't be sending a copy of NCR to the magistrate, how you will ask him to proceed further? How will you ask him to, ask for the warrant or ask for the investigation? So the particular copy of the NCR has to be submitted to the magistrate. So this is the where this all is written under section 155, right? 155 of Criminal Procedure Code. You can read. It talks about the non-cognizable reports. Then what magistrate will do? Magistrate will see the NCR and will give the order for further investigation, that yeah, you may proceed with the case, or you may do the investigations, right? What if magistrate said no, you should not do the investigation, or magistrate say there is no need of the investigation of this particular case? Even if after saying this, after this, the police inspector tries to do the investigation, and he found something. So what will happen now? If he finds that yeah, particular thing, offense is committed, and even the magistrate said not to do the investigation, if he does it, what will happen? The whole investigation will be void. Okay, it's not a curable irregularity. It's not a curable irregularity. Okay, so no, the whole investigation will be considered void. It's all written under section 155 of the Criminal Procedure Code. Now, the magistrate have asked, there are two things. Magistrate has taken the NCR. He has seen that there has to be a, the further investigation to be done or not. The magistrate has ordered. Now the police inspector is doing the further investigation, and he finds out that this particular person is to be arrested. Now he arrests the person. This will be void. Why? Because in order to arrest, he has to go to the magistrate and ask for the warrant. Then only he can arrest. So even if the magistrate has given the order for investigation, order of investigation itself alone is not considered that you will also be allowed to arrest a person. In order to arrest a person, there has to be a arrest warrant from the magistrate. So both the things are important. Order of investigation. So he wrote all those 4 offenses, and what he did was, he wrote all those 4 offenses, and all those 4 offenses he considered them to be non-cognizable, that all they are non-cognizable, and he made an NCR, right? So that NCR is made and he has submitted it to the police magistrate. Now, when he submitted to the magistrate, it was found out, no, one particular offense was not a non-cognizable offense. The 4 offenses was non-cognizable, but one of them is not a non-cognizable, it's a cognizable offense. So my question is, if an offense is committed, that like if the 4 offenses are committed against you and one of them is cognizable and other 3 are non-cognizable, right? So your case will fall under cognizable offense or non-cognizable offense. This is the main question I have. So the answer is that my case will be considered as a cognizable offense case. So if even there are 500 of the non-cognizable offense and one of them is 99 are non-cognizable and one is cognizable, your case will fall under the cognizable offenses, right? So there will be FIR registered to it, not an NCR. So this has to be, kept in the mind. So this is written under clause 4 of this particular 150. NCR and FIR, you should be very much clear. And cognizable offense and non-cognizable, there you should be very much clear. The uniformity is only created of that 3 years up and 3 years down, only in the part 2 of the schedule. Not under IPC offenses are not having any uniformity. So this is all about the FIR. Now, let's talk about complaint. Like people have a very, English is a very funny language. Let me see. Ma'am, if police finds some serious offense during investigation for which magistrate didn't give any permission, then also what the whole investigation done. If police finds some serious offense during investigation for which magistrate. Ashika, first you have to, you are asking me if during investigation the police officer finds some serious offense. Actually, in order to do the if there is a non-cognizable case and the police has to take the permission from the court, right? Permission has not been taken first and this police started doing investigation, and even if we find something important, so this will be considered null and void. You have to go through the rules. The rules are written. It's not curable. I know it sounds stupid, but it is not curable because non-cognizable offenses are not heinous crimes. Cognizable offense are heinous crimes. Okay. So you don't need to take permission. Why we have in cognizable offense? You just have a, law is nothing but a common sense. So let's put some common sense over here, that why in cognizable cases or cognizable offenses, police don't have to take the permission for investigation or for the arrest. Why? Because these are heinous crime. Police will not go, police cannot do this ki I have abhi to mere ko mil gaya hai mujrim, but अरे permission लेनी पड़ेगी फिर होगा. ऐसे नहीं हो सकता ना. So in non-cognizable, these are like punishment is below 3 years in general terms. So it's a normal crime. So you can give the person opportunity. You can ask the magistrate. You can ask the magistrate, and if the magistrate you will not take any permission, your whole proceeding will be void. So your answer is yes, the whole proceeding will be considered as void proceeding, right? So I was explaining about complaint. So now we will like everyone. I was saying English is a funny language, so complaint and FIR, we get confused. Actually, complaint has 2 meanings. In journal terms, we say complaint. Like complaint, normally I have a complaint with you that you don't study. I have a complaint. But when it comes to criminal procedure code, complaint is little more wider here. So basically, what is complaint? It is being defined under section 2D of the criminal procedure code. So complaint is like an allegation. Okay. Complaint is an allegation that this particular person has done something with me. It can be in oral form, it can be in written form, and mainly the biggest difference lies between the FIR and complaint here is that complaint has to be given to the magistrate only. Okay, you cannot do complaint to a police officer. The complaint mandatorily has to be given to the magistrate only. And magistrate ko you will give the complaint, and there is no PR, no public report, no police report will be there. Now the question is, why we have to give complaint to the magistrate and not to the police officers? When we give information to the police officer, it's like cognizable and non-cognizable, right? The police officer will do according to him. Now we give complaint that this particular person has done something to me. Now you take the action. We are saying to magistrate, now you take the action. We don't want any, we don't want to go to the police station. We are saying you take the action. You take this complaint as the cognizance of the offense. Like you consider this complaint as everything. So why complaint? Why the word complaint has been used rather than information? The answer for that is, when you file a complaint to the magistrate under 2D, the complaint where it is defined, you put an allegation against some person, known or unknown. It can be known or unknown, that I don't know who has done this. You can say this particular thing has happened, like there is some grievous hurt on me and I don't know who has done it, because it was from behind or something, or this particular person did it. So you file a complaint. Now the magistrate will see this particular complaint is a cognizable or non-cognizable, that he will consider it. Okay, so there is no role play of police. No police will be submitting in public police report and finding out whether this particular case is cognizable, non-cognizable. So the difference lies is the complaint has to be done to the magistrate only, and the FIRs or NCR, the cognizable, non-cognizable, are under the police. The police will be handling this, but the complaint will be held by the magistrate. Okay. So now what happens is, now the magistrate, Ashika, I'm explaining this only, the difference between complaint and magistrate. Oh, sorry, complaint and FIR. In FIR is actually not that कि आपको पता है कि आप FIR करने वाले हो. आप एक लेमैन पर्सन हो, आप पुलिस स्टेशन जाते हो, आपके साथ एक ऑफेंस कमिट हुआ है, आपने बोला पुलिस को जाके कि मेरे साथ ये ऑफेंस हुआ है, ठीक है, आपने उसको इन्फॉर्मेशन दे दी है. अब वो बताएगा कि ये कॉग्निजेबल है, या इसकी FIR होगी या इसकी NCR होगी. NCR होगी तो आपको मजिस्ट्रेट से सारा आपको वो लेना पड़ेगा, क्या कहते हैं उसको, परमिशन टू इन्वेस्टिगेट. FIR होगी तो इंस्पेक्टर विल डू द इन्वेस्टिगेशन. दोनों ही केसेस में, FIR और NCR में, आप जाके पुलिस रिपोर्ट सबमिट कर देंगे मजिस्ट्रेट को, और मजिस्ट्रेट कॉग्निजेंस ले लेगा कि हाँ ये केस है, मैं इसको ट्राई कर रहा हूँ, ठीक है. And when it comes to complaint, there is no role play of police in it. You are requesting the magistrate to take an action over my complaint. You're directly going to the magistrate and asking him, please take an action. I'm requesting you to take an action on my complaint. That complaint can be anything, a cognizable offense or a non-cognizable offense. That is up to the magistrate. He will see. There is no role play of police in here, right? Till now. Then the magistrate will take an action and he will consider this particular offense, and he will consider this particular offense as he'll take an action over this complaint, and he'll see whether the offense is cognizable or non-cognizable. He will see that. No police, police is not involved in the complaints cases, right? Because complaint is straightforward to the magistrate. Okay, did you get the difference between these two? So after taking cognizance of the particular complaint, like basically in complaint cases, now there is no investigation. The court will take itself the cognizance, and after taking cognizance, he will go for the further proceeding, examination and everything. That's a long procedure happening around after the magistrate take the cognizance, right? So he will take the complaint, and who actually, this is a nice question I just came up with. In every cases I'm talking, FIR, NCR or complaint cases, any cases, Which magistrate has a power to take the cognizance? Anyone can tell me which magistrate has power to take the cognizance? Who will take the cognizance of the cases? Which magistrate? Any of the person can answer me if anybody knows it. No one? So JM1. JM1 is empowered to take the cognizance of the complaints or the NCR or FIR, judicial first class. Yes, Anand Pathak, you're right. And if you see section 190, even the JM2, if empowered by CJM, will also can take the cognizance if empowered, right? So basically, if you see, the answer is JM1. JM will have a right to take the cognizance of the particular complaints or particular matters, whatever is coming to him. So now so basically the difference I told you between FIR and complaint, and if you just see, there is a very a little more difference, that complaint is a prior stage of FIR, right? Complaint is a prior stage of FIR, right? Because before FIR, you make a complaint. I said complaint not in terms of CRPC, but in general, right? So complaint is a prior stage of FIR. So this is all about this FIR and complaint and what? NCR. What else? Now, one question I want to ask. What if the magistrate, there is an information received to the police officer? Now, you just take the situation and answer me. I'll wait 5 minutes for your answer. Tell me, what is the answer for it? Everyone. Information has been, one information came up, and the person went with that particular information, the person went to the police station and he said that particular this happened with me, this offense has committed against me, please take the action. So the police says, okay, I'll take the action, and he says and police finds out that yes, it is a cognizable offense. Take it. So if he finds out that it's a cognizable offense, then he do an FIR. After filing an FIR, he do the investigation. Everything is done, right? Everything he done, and he make a PR, police report under 173, and then he submitted to the magistrate. Okay. But now, when he was submitting it to the magistrate, or when he was filing a PIR, after that he realizes, or he sees that particular case was not cognizable offense, that particular was non-cognizable offense, right? After submitting PR, or after realizing that it's not a cognizable offense, bulky, it was a non-cognizable offense. So what will be done now? What is the remedy you can tell me, or what is the what to be done now? He has done some mistake, that he considered it to be non-cognizable. He considered first at it to be a cognizable, then later find out no, it's not a cognizable offense, it's a non-cognizable offense. Now what to do? Anyone? I'm giving you just 2 minutes. 2 minutes are more than enough, so you can write, and as well as you can unmute yourself if you want to speak. Anyone? Investigation will be declared void. Avnish Upadhyay, investment nahi, investigation you wanted to write, right? Investigation will be declared void. No, Avnish, the answer is not correct. Anyone else? Like, what can be done? Ma'am, did policeman arrested anyone? Ashika, don't consider this that he arrested or not. Let it be. Okay, I would say he arrested. Okay, then tell me. At the later stage, he found out that, oh, it was, first he thought that prima facie that it was a cognizable offense, but later that he find out it to be a non-cognizable offense after PR submission. What to do? second report and then again submitted, Diksha. Diksha says they will make second report and then again submit it. No, Diksha, no, that answer is not correct. The answer is just go and look your section 2D explanation. That is, ma'am, the magistrate shall not proceed with the case as a state, but rather he shall proceed with it as a complaint case as provided, according to section 2 of CRPC. Section 2D explanation clause. Animesh, okay. Animesh says that the magistrate shall not proceed the case as a state. As a state is not correct, but rather he shall proceed with as a complaint case as provided. So yeah, Animesh is somewhat correct, not exactly correct, but yes, somewhat correct. If you see the explanation, 2D complaint explanation, if you see, I'll just read it because it's very important. A report made by police officer in case which discloses after investigation the commission of a non-cognizable offence shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be a complainant. Now he find out that it's a non-cognizable offence. So what will be happening is the police officer will be considered as a complainant, and the particular offence which particular offence which happened, a particular offence which is done, it will be considered as a complaint. So it will fall under complaint and complainant matter, right? So it will be like, I have done a complaint. The police officer is a complainant who has directly complained to the magistrate for the particular offence. Got it? So if there is a like this is happening, अगर cognizable को non cognizable offence है, पहले prima facie and उसको consider किया है कि वो बाद में समझ आया है कि वो non cognizable offence है, तो जो इंस्पेक्टर उसका पीआर जिसने बनाया है, पब्लिक रिपोर्ट जिसने, पुलिस रिपोर्ट जिसने बनाया है, he'll be considered as a complainant, right? And the particular matter will be considered as a complaint to the magistrate. So this is an explanation of 2D of CRPC. So I hope everyone is clear about it. So anyone has any question regarding FIR, complaint, criminal proceeding, anything like you want to know anything about FIR, NCR, anything?
So guys, if anybody is having any queries, either write it in the chat box, or you can unmute yourself one by one and then please do ask your questions.
Yeah, exactly. I'm waiting so that you can type it, or you can unmute yourself. It's your wish completely. Nobody's having any questions?
If anybody is having any question, please do us now. Otherwise, we will wrap the session. Ma'am, I don't think anybody is willing to ask anything now.
It's okay. Thank you so much.
Thank you so much, ma'am. Thank you to you too for such an enlightening session, and thank you for your spacious presence. Now, I would like to thank Dr. Professor Pallavi Gupta, ma'am, for heading this session, and Dr. Richa Srivastav, ma'am, and Mr. Rahul Arora, sir, for coordinating this session. And I would like to thank all the students for joining the session. It was such an enlightening session. We came to know a lot about their FIRs and complaints. Everybody knows about that a little bit, but we came to know about that in detail. So it was really a great session. Now over to you, ma'am, Richa ma'am.
Thank you, Janvi, and thank you, Kirti. I would like to extend my thanks to Kirti for this enlightenment session, as well as for gracing this occasion, and for an enlightenment session, and just making our student aware regarding the FIR and the complaint in a proper and in a deep, thorough way. And I want to say thanks to HOD ma'am for always being a source of inspiration for us. And I want to extend my thanks to Rahul Arora sir, Ajit Tyagi sir, Amita ma'am, Dr. Rahman sir, Dr. Naresh sir, Shishma ma'am, who are always there to guide me and for their guidance and support. Last but not the least, to all the students for attending this program and making this a grand success. Thank you, Kirti, once again. Kirti is an alumni
Thank you, ma'am.
and very much dear and very much close to my heart also. And she's a very brilliant student. And thank you, Janvi, for moderating the session today. And once again, thanks, Kirti, for gracing the occasion. And over to you, Janvi, now.
Thank you so much, ma'am. Now I would like to request everyone, please do open your cameras for a group photo. Students, you're requested to turn on your cameras, please.
Please, everyone, just turn on your camera. It's a humble request so that we can take a photo shoot. Karthik. Ajay sir, please, humble request. Please, it's a humble request to everyone. Please open your camera so that we can take a photo shoot.
Ma'am, have you taken the picture? Ma'am, am I
Just a minute,
audible?
just a minute. Janvi, just a minute.
Okay,
We're taking
sure.
few more pictures. We have already taken, but we are taking just few more.
All right, ma'am.
Thank you, everyone. Janvi, now you
Thank you
can
so
end the
much.
session.
Yeah, thank you
thank
so much, everyone. You may leave the session now.